Our top lead. Ladies and gentlemen, where do you draw the fine line between how justice is meted out and protecting the human dignity of an accused? The distinction that we must make is between a convict and an accused. As the saying goes, you are innocent till proven guilty. The question is a pre-trial arbitrary arrest the ultimate destruction of human dignity? The Chief Justice of India, DY Chandrachud, has drawn attention to a core responsibility of the courts: protection of lives and liberties, and the need to give a voice to those who are facing arbitrary arrests. Do you remember the case of Disha Ravi? 2 years ago, the young climate activist was arrested from Bangalore and she spent 10 days in jail. The court gave her bail as it found that the evidence against her was scanty and sketchy. Disha, just by the way, was arrested on charges of allegedly creating and sharing an online document to support the farmers' protest in 2021. Even if she was behind that document, does it justify an arrest and spending 10 days in jail? The same year, there was the case of Munawwar Farooqi. The comedian was arrested from Indore for a joke he didn't make. The FIR filed against him by a BJP MLA's son said he had allegedly hurt religious sentiments. He spent 37 days in jail before he got interim bail from the Supreme Court. These are just two examples of arbitrary arrests. Arrests that impact the self-esteem of individuals and the dignity of their families. Now, yesterday, in his Independence Day address, the Chief Justice of India did not refer to any specific case when he made his comments about arbitrary arrest. But the CJI did say that a sense of confidence and solace should be there in an individual, that the judges of the Supreme Court will be there in the event of an arbitrary arrest or a threatened demolition, or if an individual's properties are attached unlawfully. Essentially, the Chief Justice of India is saying that you, the judges of the Supreme Court, need to be the voice of citizens of India. Listen in to what he said.
Irrespective of an outcome of the case, I believe the real strength of our system is granting access to justice to our citizens. That sense of confidence of the individual that an arbitrary arrest, a threatened demolition, maybe a pension which is attached unlawfully, must find a solace and voice in the judges of the Supreme Court. As I look to the future, I believe the greatest challenge before the Indian judiciary is to eliminate the barriers to accessing justice. And we have a roadmap in place to make sure that the future Indian judiciary is inclusive and accessible to the last person in the line. To make our courts accessible and inclusive, we need to overhaul our court infrastructure on a priority basis. Our emphasis on modernizing the judicial infrastructure to meet the challenges of the future is key to this mission.
Now, this isn't the first time that the Supreme Court is saying it. Last year, in fact, exactly a year ago in August, the Supreme Court had clearly held that just because you can arrest does not mean you should arrest. They had gone on to say, and I quote, "If arrests that are being made are routine, it can cause incalculable harm to the reputation and self-esteem of a person." My guest this evening, Yashovardhan Azad, is a former IPS officer joining us on the broadcast. John Dayal is a human rights activist. He's joining us as well. I'm going to come to you, Mr. Yashovardhan Azad. This is not the first time that the Chief Justice of India has said what he has said, or the Supreme Court of India has said what they have said. They have said on multiple occasions that just because the police and the judicial system have the right to arrest an accused, it doesn't mean you have to arrest the accused, because an arrest is not merely an arrest. As a police officer, you know that. Sirf merely hatkali laga ke jail le jana is not an arrest. It has wider implications. It has implications for the individual's dignity. It has implications for the individual's self-esteem, his family's dignity and self-esteem as well. I want to ask you, why our policing system is geared towards reacting to anything at all with an arrest, despite what the top court in this country is saying.
Yeah, it's very unfortunate that in most of the cases of arrests are unnecessary. And now after that rule has come, I would say even more so. Unfortunately, in certain cases where arrests should be made, they are not done. So obviously, the first thing is that the police comes under a kind of a political pressure many of the times. And that's because we have not been able to implement the internal or the reforms which Supreme Court has talked about. Now, in cases which the Chief Justice was even alluding to, for example, these demolitions or attaching of properties or using bulldozers, there is a lot which courts can do. If there are various pillars of the criminal justice system, and if one pillar is found wanting in something, there is the police, there is the prosecution, there is the judiciary. Unfortunately, the judiciary at that particular point, especially at the lower level, fails to react. If, for example, a funny kind of a charge is being framed, they can reject framing of the charge sheet. I mean, the judiciary has immense powers, and that's exactly what Chief Justice was saying, that the lower court should do their job. For example, even when these arrests are made, in many of the cases, they can be straightaway discharged by the court. Now that the Supreme Court ruling has been there, that those should not be arrested if the crime is below 7 years in punishment, the court should act very, very tough if still the arrests are done. And I think it is also incumbent upon the Supremes of Police and the DGPs to ensure, and that the state governments also should make a record about it, even the Ministry of Home Affairs. Shreya.
That is absolutely right, because the rules are very clear. Mr. Azad, as you're pointing out, the rules are very clear. The Supreme Court says that if someone is accused of a crime for which the punishment is less than 7 years, you don't need to arrest him. Now, Mr. John Dayal, I am not suggesting that you don't arrest a serial rapist or you don't arrest a serial murderer. That's not what I'm suggesting. My point is, our entire policing system is geared towards an arrest. The fact is that over and over again, the Supreme Court of India has made it clear that just because you can arrest doesn't mean you should arrest. Today, once again, in fact, this was yesterday, not today. Yesterday, the Chief Justice of India is stepping into bat for personal liberties. But here's the thing. The thing is that when you look at lower courts, when you even in fact look at higher courts, and one of the examples that we gave was of Manavar Farooqi, what did the High Court of Madhya Pradesh say? That such people need to be punished. Point is, forget the fact that they've been arrested. Even granting bail is something that our lower courts and in many cases the high courts don't want to do, despite clear instructions from the Supreme Court.
I think what the Chief Justice has said yesterday, we should have heard from the ramparts of the Red Fort. Justice, unfortunately, is not a part of the political discourse in this country. Nobody is talking about justice. Occasionally, the Chief Justice of India talks about it, sometimes in court, but mostly in seminars and speeches. Justice, qua justice, justice as justice, is not part of the court. And therefore, you have a situation where High Court judges make such, how should I say, obscene judgments that would totally destroy justice. And of course, the police and the local judiciary, magistracy, totally blindfoldedly follow what was a colonial system and has now have been fine-tuned to convey the same sort of force on common people, to scare them, to keep them subdued. I think what is needed now is not just policy reforms. We are half a century pending. Justice Mr. Dharamvira report is more than half a century. I was a very young reporter when it was gone. Khosa report, any number of reports are there. Mr. Singh's case in the Supreme Court, the former BSF chief, those are there in the Supreme Court. So that is one stream, the need to speedify and to fructify police reforms. The other is to make the judiciary sensitive, that it is not a colonial judiciary, it's a people's judiciary. It is meant to safeguard my liberty, my rights, my conscience, My dignity is a word that you have used in your report. Supreme Court also, unfortunately, is not the Chief Justice. It is also each bench. And sometimes we have seen how benches differ in their understanding of what is civil liberties, what is there. You can understand out of the 5.5 lakh or so people in jail, 4.5 lakh are under trial. This is the speed of justice. Of them,
Correct.
many in cases, charge sheet has not been presented. There are people who have spent time in jail far more than would have been the punishment if they were guilty. If they were guilty. So here we must simultaneously talk of
Aditya Pratap.
reforms and sensitization of the judiciary, reforms of the police, and a depoliticization of the police. You see people in demonstrations carrying guns, and the police is laughing with them, joining them. This cannot go on forever.
Mr. Azad, is that a problem as well? When we talk of arbitrary arrest, that the police force is so deeply politicized that an arrest is a very convenient tool to silence or scare the opposition.
Are you asking me?
Yes, Mr. Azad.
Yeah. Let me say that the police in the various states are actually under the vicious grip of the political leadership. If you really look at it, Shreya, the reality is that the entire politics in states, they sort of revolve around police thana, tehsils. Every MLA, every MP wants his own SP, wants his own thanedar, wants his own tehsildar, nambardar, whatever you call. And that's why it lies in the severe grip
Correct.
of this. Even now, when you make the new bills, they will not succeed because the law enforcers are the one who are going to implement the law. So if they don't change and there are no internal reforms or the reforms stopped at the level of the Supreme Court guidelines, then that interface between the law and the public will just collapse and nothing will exactly happen. So yes, you're right. There is this political pressure. And the second problem is that the police leadership which you choose are unfortunately very, very lacking in the, whether it's the moral fiber or the spine. And you can make out some of the best service guys are outside the key posts and some of the most supine ones are inside. Now, how do you ensure that? There was a way of doing it, coming out of this morass, but unfortunately, no chief minister wants to get into it. And that is a very, very serious problem, Shreya.
Aditya Pratap, would you want to come in here? I wonder whether you were in the audience when the Chief Justice of India made the remarks that he did. And he didn't just speak about arrests. He also said that, if someone's property is being attached for no good reason, if there's a bulldozer threatening someone's home, he didn't mention any specific instances, but these are the words he used, then the citizens of this country need to have the confidence that the courts are their voice, that the courts will give these citizens succor. Can you help me understand why the Chief Justice of India said what he said in his Independence Day address, and what is the message that has gone down to the judiciary? Because this is a judiciary, remember, which is extremely reluctant in even giving bail. Very clearly, we remember the Supreme Court not too many days ago sending a judge from a lower court back to law school because he simply didn't follow the basic principle of law, which is, bail not jail is the norm. When you're dealing with basics here about arbitrary arrest that should not be made, bail that should be given as soon as possible, etc., and those are the very basic things that the judiciary is not delivering on, point is, how long can the Supreme Court keep saying what it is saying?
Oh, well, absolutely. Supreme Court is indeed the apex court. And, the protection from arbitrary arrest has been laid down in several authoritative Supreme Court rulings. Joginder Kumar, Arnesh Kumar, which clearly state that the IO should come to an opinion whether we need his arrest or not. Because one thing is absolutely clear. There's an FIR. It is just a prima facie allegation. Police has to invoke powers of investigation and determine whether there is evidence or not. Now, the courts have been very well aware that the moment you arrest a person on a mere suspicion, that person goes into a complete disarray. his confidence breaks down, and moreover, a very negative impression, and plus it becomes a tool for even settling scores. So obviously, in fact, I would say the Supreme Court rightly would have observed that arbitrary arrests are harmful, because the trouble is the power of arrest then becomes then gets used as a tool for pressurization. In fact, when you invoke the powers available to you in a measured and systematic manner, with a result-oriented approach, what is your objective? Your objective is to get a conviction. Your objective is to collect evidence, make a strong case. So many times it happens, like even when Sanjay Raut was granted bail by the Sessions Court, the learned additional Sessions Judge observed that the investigations keep going on, and ultimately person just languishes behind bars and there's no charge sheet. So I'm pretty sure that what was concerning his lordship's mind was that if the power of arrest was used in a measured and systematic manner, it would be more beneficial to the criminal justice system than just using it in a berserk manner, that too guided by by extraneous considerations. And which is why the Supreme Court reinforced the importance of the authoritative rulings that we have bail, not jail, which is absolutely correct. And where there is a ground made out for custodial interrogation, and plus even the court has said that merely because custodial interrogation is not required is not a ground to deny bail, is not a ground to grant bail. So I do feel that the law on the question is crystal clear, and wherever the honorable judge sees that the crystal clear law laid down by the Supreme Court is not being followed, then he would be rightfully raising his concerns with the people.
Okay, John Dayal, but is it, if you just look at it from the point of view of the police, and I'll come to Yashovardhan Azad with this question as well, but John Dayal, does an arrest also become a defense mechanism for the IO or the SHO or the Thanedar? Because often what happens, here is someone accused of a crime, you put down an FIR and you let the accused go. What is the first charge that the other side will make? The first charge that the other side makes is पैसा खाया होगा, घूस खाया होगा, सब लोग बिके हुए हैं. That's why they let the accused go, and he wasn't arrested. Therefore, is an arrest also a defense mechanism for the police to say, देखो, we are doing our work, हमने अपना काम किया है?
I was seriously tempted to say that an arrest is so much better than a false encounter or a shootout while taking a prisoner from one place to other, of the sort that we have seen in many states, particularly in UP and Madhya Pradesh. But having said that, I'm so happy that police still remain, like the army, under civilian control. And so it should be. We should not have elected police chiefs as in America. But the police must also have a sense of security. Here you are changing district superintendents of police at 3 months interval, 6 months interval. 9 months is a lucky man, and 1 year is a godsend. Fix a time for them to act and hold them culpable, hold them responsible. If things happen in his district, he should be suspended, not transferred. If things don't happen in the district, if law is being maintained, give the poor chap a chance to act. And then also, as I said earlier, in the recruitment, training, sensitization, conscientization of the constabulary, of the sub-inspectors, we must teach them constitutional values. We must teach them secularism. We must teach them equality, brotherhood. That's what the police is for, to ensure the rule of law, as by constitution guaranteed. We are not a colonial force, and we are not here in a fiefdom of politicians.
Yashovardhan Azad, would you have any view on this, given the fact that you've spent much of your life policing? You know how the police works at the district level, at the tehsil level. There's one thing to talk about reforms. I've been hearing of reforms ever since I was a journalist. I became a journalist some 17, 18 years ago. Since then, I've been hearing about how there is a need to reform the policing system in this country. That still hasn't happened, which is why I ask, does arresting an accused become a defense mechanism for the police as well, to say हमने अपना काम किया, उसे arrest कर लिया?
Actually, Shreya, you're right. Today, a stage we have reached is that the police also wants to reform itself. But the politician says, no, you're absolutely fine the way you're going. And so you just listen to us and everything will be all right. I agree with two things with Mr. John Dayal said. Absolutely right. That there should be some kind of security by way of, fixity of tenure. And secondly, there should be, these sensitivity and constitutional values inculcated during the training periods is absolutely essential. And as far as that is why, the point which you are mentioning is, to do a quick buck, a hot dog kind of a thing. Any case happens, there is a tremendous pressure, not only political, by the public also, to arrest the accused, without realizing that, premature arrest may actually, spoil the investigation. And I'm not talking about cases, I'm talking about even murder cases and, robbery cases. So the police goes in for a very, very quick arrest. So this is all because they are shaky all the time. There are two things which are very important, Shreya. And of course, they arrest and then they say, "Dekhiye, humne apna kaam kar liya." There are two things. Once you make the police immune to the threats by the politicians, and then allow them to work on their own, provided the number two part is that you post the right officers. And I'll tell you, in every state, it is well known which are the SPs who are honest, who are efficient. Everyone knows in a district, even the Panwala knows. So if you post the right ones and give them a little bit of immunity from all this, I would say even make the investigation accountable to the court so that, politicians can't interfere. That is the only problem. The other is, of course, the elements which are, prone to allure and money and who don't have the spine. That is a different thing because that happens everywhere. But if you do ensure this, that the right people are posted at the right time, and you make them fixity of tenure, give them that security, and you'll get the results.
All right. The fact is that the Supreme Court over and over again for the last many years has been batting for personal liberties. The fact also is that this advice has been falling on deaf ears. Is police reforms the solution for this? Perhaps. But till those reforms come, there needs to be some sort of sensitization that if you need to crack a case, just because you can arrest a person doesn't mean you need to arrest the person. This is something that the Supreme Court is saying, I'm not saying. We leave it there for the moment, gentlemen. Thank you very much. Yashovardhan, Azad, good to have you on the show. John Dayal, thank you very much. And Aditya Pratap, thank you very much as well. With that, I'm slipping into a quick break on the show. There's much more news coming up on the other side with Nivedana. Do stay with us.